Now, we now have before us an opportunity to further advance our joint commitment to working together to fight crime and terrorism while also protecting civil liberties and while also protecting personal privacy. We can do this. We can do so by extending the proven data protection provisions in the U.S. EU Europol, Eurojust, and mutual legal assistance agreements across the full range of law enforcement sharing between the U.S. and EU member states. Now, I should stress that such sharing already is subject to extensive data protection guarantees at the domestic level. And again, I am aware of no violations of those guarantees. But now we have a chance to consolidate those guarantees in an umbrella data protection and privacy agreement that will provide further assurances to all of our citizens. Now, this might seem like an ambitious and a complicated undertaking. In one sense, it is, because it reaches beyond specific types of exchanges and specific counterterrorism programs, such as those that are the focus of the Passenger Name Record Agreement, as well as the Terrorist Finance Tracking Program Agreement. But we have good reason to be hopeful about this effort, provided that we work from the data protection provisions we already have negotiated in other agreements, which we know to be both realizable and effective in protecting data privacy within respective legal systems. Now, while I am unable, of course, to discuss the state of current negotiations, I can report that our negotiators from both sides of the Atlantic have been working hard. Since negotiations began in March, they have met in person or by video conference 9 times for dozens of hours and have made, I think, significant progress on a number of issues that are close to being resolved. And as we continue to consider these questions and strive to work toward consensus, I would like to briefly address some of the issues that have become key areas of focus. First of all, although we can rightly celebrate the common values that underlie the various legal systems, we must recognize that basic legal structures and regulations may differ greatly between the United States and Europe. It is impractical to suggest that we can impose the particularities of our respective legal systems on each other. Instead, we must mutually recognize that each of our systems protect civil liberties, including privacy, effectively but in our own ways. This is precisely the mutual recognition that we have reached in our previous agreements, and we must do so once again. Rather than pursuing a checklist approach to see if specific rules exist under each other's systems, I would argue that our paramount consideration must be the overall effectiveness of the procedures that are already in place. Now, broadly speaking, this means accepting that different histories may breed different legal frameworks while protecting the same values that we all cherish. In fact, as we've seen, the debate about data protection between the United States and the EU is largely academic about how specific laws differ and what procedures exist in various jurisdictions, but with little discussion of the fact that the U.S. and EU member states have successfully exchanged and protected data in the law enforcement and public security sector for decades. We should work to highlight these areas of commonality, along with many other similarities between our data privacy regimes, not only when it comes to the appropriate use of information, but also the ways in which we ensure transparency in our operations. For example, in the U.S., our Freedom of Information Act provides all individuals, regardless of nationality, with a judicially enforceable process for learning what information the government has about them. Of course, both the United States and the EU must refuse individual access to some data in the law enforcement context, and when necessary, must retain information such as judicial and criminal investigative files for extended periods of time. But we have proven that transparency can be a priority without sacrificing public safety. On this front, I'm unaware of any other country that has enacted a law as powerful as the Freedom of Information Act. I would also like to note that through our collective efforts to share criminal justice information, perpetrators of the most serious crimes from all across the globe have consistently been prosecuted and brought to justice in both the U.S. and EU member states, based on the strength of evidence provided through mutual legal assistance. And we have obtained these results while at the same time protecting the privacy of our citizens. At least in part, this is because of the stringent protections currently in place in the United States, as well as Europe, to safeguard the personal data of our citizens. But I believe this commitment to privacy runs much deeper on both sides of the Atlantic than the individual rules and regulations. It is a defining principle of who we are and stands among the many common values that unite all of our nations. Now, I want to emphasize just how important those values are to President Obama, to this administration, and to me personally. I would not have had the opportunity and privilege to appear before you today and to serve as my nation's Attorney General if generations of brave Americans had not been willing to fight for equal justice, equal opportunity, and civil rights for all. In the United States and here in Europe, one of our most fundamental and cherished freedoms is the right to personal privacy. Many of the leaders in this room have spoken about this right and have stood in support of it. The United States is proud to stand with you. America's origins, as well as its modern-day systems, reflect a core belief in the importance of protecting citizens from government intrusion. Our most important legal document, our Constitution, established a federal government with limited powers and with extensive checks and balances, and our Bill of Rights ensures the freedom to speak and worship freely, along with protection from self-incrimination, as well as unreasonable searches and seizures. And the U.S. Supreme Court has determined that the right of privacy is of constitutional dimension in the United States. For more than 2 centuries, the American people have fought to defend these rights. But this is not mere constitutional history. It is the spirit that continues to guide how we view and how we protect privacy in the United States. So as our discussions continue, please know this. Not only do the American people understand your concerns about and your commitment to privacy rights, we share them. This doesn't mean that our framework for protecting privacy is the mirror image of yours. For one thing, we do not have data protection commissioners in the United States, but we do maintain other independent oversight mechanisms that achieve the same goals. Our independent inspectors general are legally obligated to uncover violations of law and policy, including violations of privacy protections. The Justice Department has a strong record of criminal prosecutions in this regard that I believe is untouched by any other country. In fact, between 2009 and 2010, we prosecuted 18 defendants in U.S. federal courts for crimes that were essentially data protection violations, such as unauthorized access to personal data or misuse of personal data. Privacy officers are also embedded in our government agencies and similarly are charged with ensuring that privacy laws and policies are enforced and that privacy concerns are taken into account as new policies are developed and implemented. Indeed, I'm confident that the robust protections that we've built into our data collection programs are second to none. In addition, the United States Congress is responsible for rigorous oversight of government agencies' privacy protections, and our Government Accountability Office, which is an arm of our Congress, frequently conducts investigations across government to fulfill this important obligation. And in discussing this topic, I feel it's important to note that in a number of significant contexts, and contrary to the popular perception of many within the EU, privacy rules in the United States are stricter than those within the EU. For instance, in the critical context of securing the interception of a telephone or email account during a criminal investigation, the U.S. has among the most, if not the most, stringent requirements in the world. Similar levels of scrutiny accompanied by equally robust protection are applied in the United States to other forms of personal information, including the results of DNA testing, health records, financial records, and tax information as well. Moreover, as implemented, our privacy laws provide comparable protection to all people. Now, when you consider all of this, it is hardly surprising that EU and U.S. privacy experts, after careful studies over 3 years in our joint high-level contact group, together concluded that both the United States and the European Union have, and I quote, have important commonalities and a deeply rooted commitment to the protection of personal data and privacy, unquote. It was on this basis and in the light of our record of successful and mutually beneficial information sharing agreements with Europol, Eurojust, and under the Mutual Legal Assistance Agreement, that the U.S. and EU first agreed to pursue a binding data privacy and protection agreement. Now, as negotiations continue, I am hopeful and optimistic that our commitment to cooperation will remain strong, and that if we mutually recognize that our respective systems both protect civil liberties, including privacy, effectively, though at times differently, then we will be able to draw on our experiences operating under existing agreements and treaties to create an umbrella agreement that will enshrine these achievements in a comprehensive form for the future. No matter the challenge, no matter the obstacle, no matter the differences that at times can seem to divide us from one another, we are and always will be and always must be partners. We are united by our values, by our shared responsibilities to protect the security and the civil liberties of our fellow citizens and to carry forward the difficult but essential work of building a more peaceful world. Now, this is the challenge that lies before us. So today, let us pledge ourselves to this work once again, and let us do not just what is necessary, but what is right. I want to thank you for hearing from me, and I now look forward to hearing from you, and I will be happy to answer any of the questions that you might have. Thank you very much.